Ladies and gentlemen, welcome to the village board meeting of April 13th. This meeting will be conducted on premises and via Zoom as allowed by Governor Pritzker's executive order. Oh, Mrs. Thomas.
Trustee Dawkins,
Here.
trustee Purcell,
Here.
trustee Washington, trustee Roman,
Here.
trustee Heiferman,
Here.
trustee Burnson has resigned as of April 1st. Mayor Hofeld,
Here. Representing staff this evening, to my left is our village attorney, Chris Cummings. To my right is our village manager, Jim Marino. Also in attendance is our police chief, Denise McGrath, and via Zoom, finance director, Dennis Bubenek, assistant manager, Napoleon Haney, public works director, John Schaefer, and fire chief, Bob Grabowski. The minutes of the meeting of March 23rd. Any additions or corrections? Trustee Dawkins.
None.
Trustee Purcell.
Nothing.
Trustee Roman.
Nothing.
Trustee Heiferman.
I have none.
I have a motion, please.
So moved. Roman.
Second, Heiferman.
Been moved by trustee Roman, seconded by trustee Purcell to accept the minutes. Roll call, please.
trustee Dawkins,
Aye.
trustee Purcell,
Aye.
trustee Roman,
Aye.
trustee Heiferman,
Aye.
The minutes are approved. The claims list in the amount of $1,022,449.35. Again, trustee Dawkins, comments are correct.
None.
Trustee Purcell.
All good.
Trustee Roman.
I have nothing.
Trustee Heiferman.
Any questions have been answered.
May I have a motion to approve the claims list, please?
So moved. Purcell. Second. Roman.
Been moved by trustee Purcell, seconded by trustee Roman. Roll call, please.
trustee Dawkins,
Aye.
trustee Purcell,
Aye.
trustee Roman,
Aye.
trustee Heiferman,
Aye.
Claims list is approved. Of that claims list, a little over $1 million, two items comprise better than half of that. Our payment to the city of Harvey for water was $293,000, and 1 month's employees' health insurance was $224,000. That amounted to $517,000, or 51% of that claims list. Hear from the audience. If anyone would like to address the board on any subject not on the agenda, please raise your hand. Yes, ma'am.
My name is Danielle Nolan Ragland. I'm a taxpaying resident of this village. First, I want to start by saying Black Lives Matter. Second, I want to say that as a resident of this village, in light of the recent events and not so recent events, because these things keep happening, the number of activists that have asked for a comment from either the trustees or the police department or the village at all regarding what is happening to people of color in this country and what we are doing here to fight it. And it's to my understanding that we have heard nothing in response. I would like it to be recorded. I would like for it to be made known that we are not pleased and that we would like to feel as valued as we should, as we make up part of this community. And we would like to know what the Homewood Police Department is doing in terms of diversity training to ensure that all officers, all detectives, everyone that interacts with the people in this community knows how to interact with the people of this community. Most of them don't live here, so they aren't familiar with us. They need to know who we are and they need to know why we matter. Thank you.
Thank you. Reappointments. At this time, I would like a motion to approve the reappointment of Maureen Alfonso to the Planning and Zoning Commission, Bill Mason to the Economic Development Committee, Andrew O'Meara to the Fire and Police Commission, Chuck Lawrence to the Stormwater Resource Committee, Rich Lights to the Ethics Commission, and Tisa Jones to the Veterans Committee. May I have such a motion, please?
So moved. Heiferman.
Second. Purcell.
Been moved by trustee Heiferman, seconded by trustee Purcell. Roll call, please.
trustee Dawkins,
Aye.
trustee Purcell,
Aye.
Trustee Roman,
Aye.
trustee Heiferman.
Aye.
The appointments are confirmed. Item number 9, resolution R 3078, an intergovernmental cooperation with Calumet Country Club property. Please note, this is a statement of intergovernmental cooperation. It is not an agreement. Mrs. Thomas?
A resolution in support of intergovernmental cooperation between the villages of Hazel Crest and Homewood regarding the future development of Calumet Country Club. Whereas for over 100 years, privately owned Calumet Country Club has provided recreation for its members and employment opportunities for the surrounding communities. And whereas for 40 years, most of the club property has been located in the zone as undeveloped open space, with the remainder of the club located in the village of Hazel Crest and zoned for commercial uses. And whereas after years of declining membership and financial difficulties, the club's owners sold the property to a private developer. And whereas because of recent litigation between the private developer and the village of Homewood, the future of Calumet Country Club is uncertain. And the village president of the village of Hazel Crest recently released a statement opposing redevelopment of the club into a logistics facility, requesting that the village of Homewood partner with Hazel Crest to keep the club a green area. And whereas the Homewood Village Board agreed with the village of Hazel Crest position and refused to rezone the country club property for industrial development, because this would adversely affect residents of Homewood and the surrounding communities. Now, therefore, be it resolved by the president and the board of trustees of the village of Homewood, section 1, support of intergovernmental cooperation. The president and board of trustees hereby express their wholehearted support for intergovernmental cooperation between the villages of Homewood and Hazel Crest regarding any future development of Calumet Country Club. Section 2, effective date. This resolution shall be in full force after its passage, approval, and publication in accordance with the law. Passed and approved this 13th day of April, 2021.
Thank you. May I have a motion to approve resolution R 3078, please?
So moved, Purcell.
Second, Dawkins.
And moved by trustee Purcell, seconded by trustee Dawkins. Roll call, please.
Trustee Dawkins,
Aye.
trustee Purcell,
Aye.
trustee Roman,
Aye.
trustee Heiferman.
Aye.
Resolution is approved. It should be noted that I sent this to Mayor Alsbury yesterday, and he commented back that it looks okay, and he will present it to his board as well. The omnibus vote, Mrs. Thomas.
The board is asked to waive competitive bidding due to the use of HGAC BUY, a nationwide government procurement cooperative, and authorize the purchase of a 2-ton hot asphalt hauler dump trailer for $42,625. The board is asked to approve a raffle license for a Queen of Hearts raffle for Glenwood Academy, selling tickets through the 5th Quarter Press Room and Eatery. The prize is capped at $5,000 and tickets can be sold for up to 1 year. The board is asked to approve resolution R 3079, appropriating $25,000 of motor fuel tax funds for street patching work from May 1 through April 30, 2022. The board is asked to renew the general retainer agreement with Lehner Muchen Limited of Chicago for labor law services. The retainer will extend from May 1 through April 30, 2023. The board is asked to approve a budget amendment of $41,000 to the Washington Park Plaza sales tax account, increasing the line item to $230,000. This will cover underfunding in the account due to a COVID-related tax revenue decline. The board is asked to approve ordinance M 2164, allowing for the disconnection of Calumet Country Club property from Homewood pursuant to a settlement agreement reached with WNE Ventures LLC. The judge hearing the matter has clarified that the board can move forward with the disconnection in keeping with the timing set out in the agreement. The board is asked to approve ordinance M 2178, suspending outdoor liquor license requirements to encourage outdoor food and liquor service during the pandemic. The board is asked to approve ordinance M 2179 that will rebate a prorated amount equal to 3 months of the annual liquor license fee to restaurants and bars licensed for on-premise consumption of alcoholic beverages in response to COVID-19 mitigation restrictions.
Thank you. It will be noted that items E and F will be voted on separately. So we are looking at items A, B, C, D, G, and H as part of the consent agenda. Any comments or questions from anyone in the audience with regard to those matters? Board comments, trustee Dawkins,
No comments.
trustee Purcell,
I'm good.
trustee Roman,
Nothing.
trustee Heiferman.
I have no questions.
May I have a motion to approve the aforementioned items?
So moved,
Heiferman.
Dawkins.
So was that a motion, trustee Heiferman?
Yes.
And is there a second?
So moved, Dawkins.
Been
Second.
moved by trustee Heiferman, seconded by trustee Dawkins. Roll call, please.
Trustee Dawkins.
Aye.
Trustee Purcell.
Aye.
Trustee Roman.
Aye.
Trustee Heiferman.
Aye.
Those items are approved. Item E, budget amendment for Washington Park Plaza incentive. Any comments or questions? Board comments?
None.
Trustee Purcell,
Nothing.
trustee Roman,
Nothing.
trustee Heiferman.
I have nothing.
May I have a motion to approve item E? And I have to vote on that as well to get five votes.
So moved, Purcell. Second, Roman.
Been moved by trustee Purcell, seconded by trustee Roman. Roll call, please.
Trustee Dawkins.
Aye.
Trustee Purcell.
Aye.
Trustee Roman.
Aye.
Trustee Heiferman.
Aye.
President Hofeld.
Aye. Item number F, ordinance M 2164. Voluntary disconnection of property. And again, I'd like to remind everyone that village board meetings are not public hearings, but rather are public meetings. And as such, public comments are time limited and will be non-repetitive. Agenda items will be discussed as we always do with respect to and from the board, the staff, and members of the audience. After all, we are Homewood. With that in mind, tonight we shall hear any additional comments that the staff or members of the audience would like to provide. Mr. Cummings.
Ladies and gentlemen, members of the board, tonight's agenda, the village board will consider passage of an ordinance disconnecting the majority of Calumet Country Club from the village of Homewood. Passage of this ordinance is required by the settlement agreement that the village board approved on January 26, 2021 to resolve the disconnection lawsuit filed against Homewood by the property owner. To disconnect from Homewood, the property owner must prove 7 requirements. 1 is the property is over 20 acres. 2, property is on the border of Homewood. 3, if disconnected, no portion of Homewood would be isolated from the remainder of the village. 4, if the property is disconnected, the village's growth prospects and planning and zoning ordinances would not be unreasonably disrupted. 5, if disconnected, there would be no substantial disruption to existing municipal services such as sewer systems, street lighting, water mains, garbage collection, or fire protection. Number 6, if disconnected, the village would not be unduly harmed by a loss of tax revenue in the future. And 7, at the time that the disconnection is filed, the property is not in a TIF district. If the property owner can prove these factors, the judge must disconnect the property from the village. Whatever the property owner intends to do with the property once it's disconnected from the village is absolutely irrelevant to the judge that's hearing this case. Since this case was filed in mid-2019, myself, along with attorney Greg Smith from Klein Thorpe, which is another law firm in Chicago that specializes pretty much exclusively in municipal law, and I have reviewed every facet of this case and read every court opinion interpreting the statute. Based upon our research, it became clear that the village would have little to argue if this case went to trial. The property is over 20 acres. It's on Homewood's border and generates minimal property tax revenue when compared with the village's overall budget. Just the numbers. This property, the only tax revenue the village received from this is approximately $27,500 a year. Homewood's general fund budget is $22 million. So this is far less than 1%. The property, other than a drainage easement, which whoever owns the property or develops it in the future is going to have to abide by and honor, it has no other municipal facilities on it other than that drainage easement. The property, when the disconnection suit was filed, was zoned as open space, and the village had no development plans in place when this lawsuit was filed. As far as isolation, there is a tiny piece of property that was included in the original annexation agreement, and where that legal description for the annexation agreement came from back in 1980 was from the club owners. We've researched this. That small piece of property, which is on the eastern portion of the Homewood portion of Calumet property, was probably owned by the state of Illinois as part of Dixie Highway. And as a result, it probably, from our research, that tiny piece of property probably was never entitled to be annexed into Homewood in the first place because the state did not petition to annex that property. In addition, the court cases interpreting this disconnection statute have consistently ruled that it should be liberally construed in favor of the property owner's right to disconnect. And just as by way of background, if you read some of the cases, this is not the first golf course case. There are several previous cases involving disconnections of golf courses. The one in particular that comes to mind is from Palos Hills, and it was a similar situation with the Palos Country Club. And a portion of that, the village of Palos Hills objected at that time, or it might have been Palos Park, but the reality is the property ended up being disconnected and annexed into Orland Park and was subsequently developed. So this is not a new topic as far as disconnecting golf courses, unfortunately. The village board approved the settlement agreement back in January because it was highly likely the property owner would win his case and disconnect. Settling the case and rezoning the property would have kept it in Homewood and provided the village with some say in the property's future development. The settlement agreement is a contract between the village and the property owner. The agreement required the village to consider, not to approve, but to consider rezoning the property. The Planning and Zoning Commission conducted 20 hours of public hearings and unanimously recommended that the property not be rezoned. The village board followed their recommendation and did not rezone the property, which is why we are here today. Since the village refused to rezone the property, the agreement required the village to disconnect the property. If the village does not disconnect the property owner most assuredly will sue to force the village to do that, to disconnect the property. And if that happens, the village will have, according to the settlement agreement, would be also on the hook for the developer's legal fees and damages that are proved. Last month, several residents asked that they be named as additional defendants in the disconnection case. The judge ruled that according to law, they had a right to be added as defendants. After this ruling, the attorney for the residents sent a letter to myself and the village claiming that because the court added these residents, that somehow this settlement agreement was void or voidable. And if we chose to move forward with this, as we were obligated to do, that the attorney would ask the court to impose sanctions and ask to hold us in contempt of court. We filed a motion, an emergency motion the next morning, April 6th. We were in front of Judge Ward Kirby, who's been handling this case since 2019. And she told everybody at that time, and she ordered that by allowing the interveners into the case, which she believed was their right to intervene, it did not avoid the settlement agreement. It did not make the settlement agreement voidable and did not modify any of the village's obligations under the settlement agreement. Excuse me. The bottom line is the village is legally obligated to honor the settlement agreement by approving the disconnection ordinance. While this is not the desirable outcome, the village's failure to abide by the settlement agreement would not change the ultimate outcome and could cost the village and its taxpayers far more than the thousands of dollars it has already spent defending this case for the past 22 months. And the final thing that I would add, I've seen a lot of the comments out there about our performance on this, and I'm talking about the legal staff on this. Attorneys can differ on different things, but I would not be honoring my job by encouraging the village to go ahead with this lawsuit at this point. That is what I've said from the start. I told everybody back in 2019, when we met over in the auditorium next door in the pre-COVID times, that the village may be stuck making the best bad deal that it can because we don't have a lot of leverage with this. The property is surrounded on 3 sides by another municipality. And the reality is if the developer can meet those 7 standards, then he has a right to disconnect. And that's what we are faced with. And that's why I advised the village board, along with Mr. Smith, to go ahead and pursue the settlement if the village board was willing to do that. And that was our intention, and that's what we did. Thank you.
Thank you. Mrs. Thomas, comments that you've received?
The village has received more than 30 comments, and people speak to their objection to the disconnect.
Okay, thank you. Audience comment.
Mr. Hopefeld, just to be clear on the record too, in addition to the summary that the village clerk just added, all of the comments that were received, number 1, will be included in the minutes of tonight's meeting, and they also been distributed to each one of the trustees and made available to them for them to read prior to their voting tonight.
Thank you. Audience comments.
Good evening. My name is Patrick Keating. I am an attorney, and I, along with James Tunick, who is also here, represent the 5 Homewood residents who are now your co-defendants. Just a little bit of my background. I am a graduate of Princeton University and the Notre Dame Law School. I won't say how many years ago, but I have been practicing complex multi-party civil litigation for more than 28 years and appellate work as well. I've argued appeals in the state appellate court, in the state Supreme Court, and in 4 federal circuit courts of appeal from San Francisco to New York. For the last 21 years, I have been honored to hold the highest rating of AV from the peer-reviewed Martindale-Hubbell Directory of Counsel, which has been rating attorneys since 1868. I want to be very clear about the request that we are making of the trustees tonight. We are requesting that the trustees vote no or against the inaction of the proposed ordinance M-2164, which I believe is item 10F on the agenda. And in the alternative, and I think especially given that there is while there may be technically a quorum, there is a shortage in the trustees today, and there are some questions about whether this agenda was physically posted here, we would request that whatever parliamentary motions are necessary to postpone the motion for approval of this ordinance to a future date be taken. And for the reasons I state, that will become clear. The basic reasons are this. The court on April 1st granted the 5 Homewood resident taxpayers the right to appear in this case as defendants, the right to defend the petition, even if Homewood no longer chose to defend the petition. That's what we were granted. That was the first time in since 1936 that has been done. If the court or if the trustees were to vote on this ordinance now, they will basically be doing an end run around court approval of the settlement that everyone else says is so valid and enforceable. There are three basic reasons why the trustees should vote no on this ordinance tonight. The first is that there is no obligation to follow this agreement. The agreement, contrary to the representation that was made, the agreement was never ruled valid by the court. All the court issued on April 5th was an order clarifying that its order letting us in did not automatically invalidate the settlement agreement. That nothing that the court ruled on that day was void. The court was quite clear that the settlement agreement had not properly been placed before it, and that it was not ruling on the validity of the settlement agreement. The court has not approved the settlement agreement. And in fact, what you are being asked to do today is to enact an ordinance so that the developer hopes the court will never have to approve the settlement agreement. I'm happy to discuss these legal issues in more detail. As co-defendants, we have every right, if we are invited, to participate in any sort of executive session to discuss this litigation. And anything that is discussed between the village and our side can be.
Mr. Keating, you're running to the end of your time.
Well, my time here is short. I'm happy to speak again. The memo that you received said that the defendants have failed to show how they could successfully defend the disconnection lawsuit. We're not going to discuss our trial tactics in an open forum, but we're happy to do so privately. And we have looked at it very carefully, and this case is winnable on disconnection. The burden of proof is on the plaintiffs and not on the defendants, and we only have to win on one issue. What some attorneys view as case law roadblocks, experienced appellate and trial attorneys view as road maps for how to present the expert evidence in such a way that you win at the trial court level and that you preserve that decision at the appellate court level. And I have no issues with that. You are free to, and you should disregard the so-called requirements of this agreement. The agreement is void. It is void for 5 reasons. The main reason is because we have appeared as interveners. And
Mr. Keating, you're out of time.
okay, I would ask for more time. You counsel
No,
has
sir.
8 minutes.
We have rules in place. No, sir, we can't designate that.
I'm just going to refer to your counsel packet, the highlighted sections of the case Drury versus Village of Barrington Hills. The appellate court will absolutely grant us the right to object to this objections, and we'll be back here in 2 years if you vote for the ordinance today.
Thank you, sir. Anyone else? Yes.
Hi, my name is David Sachs. I live in Flossmoor. I encourage you to vote against disconnection of the property, to not settle, and to defend against disconnection in court in a civil trial if necessary. The Calumet Country Club land represents over 20% of the open parkland in Homewood. The zoning board and yourselves eloquently stated the case against an industrial development on the land. These same arguments, ranging from the disruption of municipal services to Homewood's long-term environmental and development plans, can be made in court. Walt Brown publicly stated on Facebook his hope that this settlement agreement would fail. Handing him disconnection via voluntary ordinance, is doing his job for him and is not in the interest of the village or its residents. At this late stage, I don't know if you'll be swayed by these arguments from the community. I'm sure it's tempting to disconnect the land from Homewood and be done with this controversial and heated issue. If you do go that route, please know that I and many others do not consider this an end to your responsibilities for this land. If nothing else, it should be obvious that all of you entered into a settlement agreement that your constituents and community do not support. I appreciate the resolution that was just passed earlier tonight and the spirit of cooperation that it represents. However, if the land does go to Cook County, it is more important than ever for you to reach out to your colleagues in Hazel Crest for an intergovernmental agreement. Mayor, I hope I'll clarify this. Tonight was not an agreement. It was merely a resolution. Working on an actual agreement with teeth that you guys both sign is incredibly important. An agreement that both opposes development and works towards land being managed by the Cook County Forest Preserve District or the Park District or a similar government entity. Mr. Marino and Mr. Cummings shouldn't be expected to simply wait for something to come from Hazel Crest or the county. This issue requires your leadership as trustees to do proactive outreach and engagement, the exact thing that was sorely lacking for the entire settlement process. Please vote against disconnection. Walt Brown is the one that should fear a civil trial, not the village. As Mr. Keating said, the burden of proof is on him. We have the facts and law on our side. But if you vote yes, please know that this issue is far from over for both the residents and the village of Homewood. We expect more of you. Thank you for your time.
Thank you, sir. Anyone else? Ma'am.
My name is Liz Varmecki. I'm a resident in Homewood. Despite every effort the community has made to help the village extricate itself from the horrible place that you agreed to be put in, you feel you don't have a choice to use your prerogative as elected autonomous individuals. And that would be because you would be breaking an agreement that you entered into. And you can't even tell the residents about the potential specific penalties for breaking this contract. Although Mr. Cummings did clarify that tonight. But any eventual bad outcome that may occur as a result of this monumentally bad decision by the Board of Trustees to approve W&E's settlement agreement on January 26th is a result of that. Since the meetings immediately after the disconnection suit was filed in 2019, you were unwilling to be frank with the residents about how the process was going because of pending litigation. And since you voted on the settlement, you haven't been honest and open with residents because now you claim you're bound to silence by the settlement or legal advice or both. But you're not required to go behind closed doors to discuss litigation. You choose to leave residents in the dark. So as you spent months negotiating the height of the berm and the prospective development and the amount of feet buildings were going to be set back, you never asked anyone in Governor's Park whether those two very small consolation prizes would be enough to make up for the destruction of their property values, way of life, and potentially their health. And from canvassing in Governor's Park, I gather that none of the trustees are Governor's Park residents. That's a paternalistic way to run our municipal government. If you are representing the village residents of this, the residents of this village, then listening to your constituents must be part of your job. And sharing is equally as important as listening in the communication process. This is an aspect of your job that you failed at. No one on the board has worked to make this government legitimately more open and transparent to residents. I submitted a question to the fateful January 26th meeting that went unaddressed. Of course, it's in the public comments, as also stated tonight, but it's still not been addressed, and I think it's super crucial. It went something like this. If you did everything in your power to stop this developer from destroying this space at a detriment to the entire community, then what proactive actions and ordinances can this board take to protect our other green spaces that are clearly so vital to the residents of this community? If the rezoning of this property is wrong in Homewood, then it's wrong everywhere. If we know the motive of the disconnection is to rezone the property and develop it, it's still wrong. Working with Hazel Crest, as the resolution indicated, which is great, but to create an intergovernmental agreement to save the space and make it beneficial for everyone in the Southland is honestly the most sensible thing to do. But most importantly, it is unethical for the village to enter into a settlement requiring trustees to abdicate their legislative responsibilities for the residents of this village to an outside party. You have let a non-elected, non-area resident force you into voting for an ordinance.
Ma'am, your time is up.
If it is not illegal, it is unethical, and it shows very serious problems with the governance of this village.
Thank you.
Thank you.
Hi, my name is Jenna Weglars, and I am a Homewood resident. I have lived here most of my life. This is a place I call home. It's a quaint village with an abundance of tree-lined streets and parks. The village does a great job with community events where you can meet your neighbors and celebrate the community. It has a world-class park district that people adore, but most importantly, it has a close-knit family feel to it. There's a strong sense of community and camaraderie that you cannot find anywhere else. People who move to other towns may have bigger houses or wider communities, but they lose their feeling of home. I've talked to people who've moved away, and that's the one overwhelming response I get from them. We have something special here. something worth fighting for, something we need you to help us continue to fight for. When I joined on to this grassroots campaign to save our village, I never thought I would lose friendships over this. I never thought I would be painted the bad guy. I never thought that standing up for something that all the residents are against would cause me so much stress, anxiety, and sadness. I never asked for and didn't go looking for this fight. However, I also never in my wildest dreams thought I would be part of something bigger than me. I saw a community come together quickly as a united front to say, this is not what we want. People send me messages to thank me for what I'm doing. That makes it worth it. I told myself, I don't know what I'm doing here. I'm not an activist. I'm a teacher and a hairstylist. I coach T-ball. I like to plant flowers and bake sourdough bread. But I'm here and I'm determined and I don't give up. And I'm asking for the board to not give up too. On us, on your neighbors, on this village. I'm asking the board to vote to not give in to the bully, Walt Brown. If you don't try, there is no opportunity to succeed. I joined in the fight when I felt my village gave up on me. I think we can all agree that the settlement agreement does not settle anything. It rolls over and gives Walt Brown everything he asked for and then some. You can and should vote no to the disconnection and allow for a trial on the actual legal merits as to whether Walt Brown and Diversified are entitled to disconnect as a matter of law. Nothing is guaranteed in court, but there are numerous and material prongs on the 7-step disconnection test that Walt Brown must satisfy that he cannot. His failure to meet even one of these thresholds is fatal to his application for disconnection. I need the board to stop being afraid of what could go wrong and start being positive of what could go right. You know the detriment that will come to our village and this disconnected and then developed into a trucking facility. You know the harm this will be to the people, the harm it will have on our children and our children's future, the harm it will have on additional flooding, to the decrease of property values, to safety and well-being of people's health and happiness, and not to mention the destroying of our ecosystem. I just got one more thing. You listen to the zoning board and the citizens who pointed out the detrimental harm it will cause, and you voted no on the rezoning. You took an oath to support the Illinois Constitution when you entered into office for the village. You stood where you are now and said, I have been appointed to the office of trustee for the village of Homewood. Do solemnly swear that I will support the Constitution of the state of Illinois. Voting for this disconnection simultaneously violates a trustee's oath of office and the Illinois Constitution. Allowing the disconnection and eventual destruction of a quarter of Homewood zone green space is clearly violative of the environmental principles enumerated in Article 11 of Illinois Constitution. If you vote yes, you are voting against the oath that you took.
Anyone else? Yes, ma'am.
I'm Carrie Anderson from Flossmoor. Just being clear, I'm not an attorney, but because my understanding is our attorney asked to meet with the trustees so that we could present our case and you'd have more information, and that was declined. I just want to try to finish Patrick's thoughts, but I'm not an attorney, so I'll try my best. But Patrick and Jim are excellent attorneys with years of experience. Patrick wants you to know that that Judge Kirby has not considered the case that I understand is highlighted in your packet, Drury versus Village of Barrington Hills. And that the appellate court has said that settlement agreements can be voided when there are other defendants, co-defendants like we currently have. So, you know, both defendants have to agree. So the village can't just on its own say, yeah, we'll do this. and neither can the co-defendants. It has to be an agreement of the two. So we want you to understand that we have a very strong case. We also want you to understand that we believe, so if a settlement is agreed to, but it was based on a mutual mistake of fact, then it is voidable. And the mistake of fact is everyone seemed to believe that Hazel Crest was going to build this dirty trucking hub. And is that true? And Walt Brown seemed to tell you it was. Is that fraudulent that he did? He bragged on social media that he hoped he could get it in Hazel Crest because then he doesn't have to build his berm and he can save $1 million. Like, what the heck, you guys? You were either the wool was pulled over your eyes and you were defrauded, or there was a mutual mistake of fact. And in either case, the settlement agreement is voidable. I don't know what else to tell you, just that if you just have to have faith and you have to have grit. Walt Brown bought a golf course. He knew it. He can't bully us into giving up the land. Like, why would we let him? Thank you.
Thank you.
Thank you for the time. My name is Kevin Crabtree. I'm a resident tax-paying homeowner here in Homewood, Illinois. And I've lived here for 8 years. I'm coming up on 8 years. And my 39 years of living, it's been between East Hazel Crest, Bremerton Woods, and here in Homewood, Southgate. Trustee Dawkins, Barbara. Trustee Heiferman, Jay. Trustee Purcell, Lisa. Trustee Washington, Karen. Trustee Roman, Lauren. We are neighbors. We are neighbors. We have an obligation to do what's morally right and to take our time in such matters like this. I'm a father. I watched my life play out filled with hardship, health problems with my mom. She's no longer with us. 30 years of cancer filled her life and she prospered through it, but it ended short. So she's here with me now. What would your parents be doing in this moment right now, knowing that you're responsible for the future of this village? That the decision you make tonight will affect every parent, every child, every resident of this town, for now and forever forward. This cannot be taken lightly, and it takes time. We have a relatively very short amount of time that the Homewood Five have been allowed on this case, and it takes discovery. And to the points that have been made, Walt Brown and Diversified Partners must satisfy their 7 points. And we need the time for you and your co-defendants, your neighbors, Homewood residents, to join with you against the harm and the detriment that this will do forever forward. Imagine what it's like for the people of Governor's Park in their front yards. Step out of your office right now in front of that camera and think about what it's like for them to go home tonight and not know that they will have the serenity, the peace, the value, the health, everything that's important to them. I've walked the streets. I've talked to these neighbors, point blank, hundreds of people. It is terrible to hear the fear and the mistrust that they have in this entire situation. I think you know that your hearts are in the wrong place if you agree to disconnect.
Mr. Crabtree. your time
Please
is
do
up.
not disconnect for the sake of time. We are literally days away from a trial hearing. Allow it time. Please do not disconnect for what's right in your hearts and what's right for the humanity of our neighbors, your neighbors of Homewood,
Okay,
your
thank you, Mr.
teachers,
Crabtree.
your firefighters, your policemen, your doctors, your healthcare, your daycare.
Mr. Crabtree, that's time.
It's too much. Do not do this. No to disconnection.
Thank you. Is there anyone else?
Good afternoon. Good afternoon, trustees. Good afternoon, board. My name is James Tunick. I'm an attorney in Chicago. I live in the village of Homewood. I've lived here for about 13 years. My children were born here. I have, as I said previously at a zoning commission meeting, I've coached Little League. I coached the Homewood baseball metro team for the last 3 years. I'm active in the community. This is, I want to talk as a lawyer, not necessarily as a resident, but I have feelings both ways, certainly. I'm not going to be long in any respect. I think Patrick Keating covered our issues. I joined as additional counsel with Patrick because this was a good legal fight that had a lot of substance to it. And just a little background on me, I'll be real brief. I've tried cases throughout the United States. I've tried cases in Newark, New Jersey, in Texas, in Indianapolis, complex cases. And I felt that this case is something we could bring to trial. Absolutely. The taxpayers have rights, okay? And that's what Chris left out. The statute, Judge Kirby acknowledged what by allowing the interveners in the lawsuit, she acknowledged that the taxpayers have rights. The statute specifically lays out the rights of the taxpayers. We only named 5 taxpayers in the lawsuit. We could have named 100 easily. There's no question about that. And it gives them the right to contest the disconnection. If you vote to allow the disconnection, you're stripping the taxpayers of the rights that are outlined in the disconnection statute. That's it. That's really what it comes down to. It's as simple as that. You're stripping them of their right to contest it. The issue will then become moot, as a court would say, and then there's no fight. A fight that we're prepared to take, and we would love for you to join us, because if you joined us, we would have more power and we would win the lawsuit. And specifically, as Dave Sachs and Patrick said, the burden is not on us to show that disconnection is improper. The burden is on the person who filed the lawsuit against our village. That's who the burden's on. And the issue, and without getting into legal, subtleties and, legal description, but the second issue that Chris Cummings laid out, and that he, keep in mind that lawyers can differ. I mean, the Supreme Court votes, 5-4, and they differ on the law. And Chris has his opinion, but it doesn't mean it's right by any means, okay? And disrupt the growth prospects of the village of Homewood. Well, I can tell you, you put that into that turns into a trucking hub, and I know there's a resolution, but we can't kick the can to somebody else and say it's your responsibility.
Mr. Turner, your time is up. Sum it up, please.
Yeah, I'm gonna sum it up. Can't kick the can out. You can't just kick it because we don't know what someone else is gonna do. We can fight this lawsuit and win it. And if you think that lawsuits, that Chris can predict the outcome of a lawsuit, you're absolutely wrong. He can't.
Okay, Mr. Turner, your time is up.
So we can fight on certain elements of this lawsuit. And can I stand here and guarantee you that we're gonna win? No.
Once again, Mr. Turnick,
But
your
we're
time
gonna
is up,
put
please.
our best
Will you
foot
please?
forward and continue this
Mr.
fight.
Turnick,
You've been asked several times.
thank you. Is there anyone else?
Okay. Again, my name is Danielle Nolan Ragland. I'm a taxpaying resident of this village. We've talked a lot amongst ourselves about what to say, what impressions we need to leave on you, what will pull your heartstrings. How angry, how emotional, how passive, how aggressive, how anything we should be to get you to do what we want. I don't know the right move, but I'm gonna do what feels right for me here tonight. So I'm here as a mother, a daughter, a wife, a friend, and a Black woman that has lived in this village for over 30 years. It needs to be said that you all made a mistake in January when you voted for this settlement. It's one-sided and developer serving at best. We deserved better. The village attorney has a habit of not even looking in the direction of the people at those speaking at the podium, let alone listening to us. So I can't imagine what advice he gave you on our behalf. Hear me now, Mr. Cummings. Please hear us, trustees. We, the citizens of this village, adamantly oppose this. We have made it clear we are not in favor. We have activated in the thousands to make our voices and our wishes loud and clear. We trust that you would see us, we trusted rather, that you would see us as cohorts, not adversaries. Instead, you've made it clear that you think we're idiots. You think we're annoying. You think we're assholes. You've continued to praise someone who, while working in our village hall, while doing village business, while being paid village taxpayer dollars, both threatened our safety and laughed at the idea of violence being used against us. You continue to employ someone who threatened the use of the police force to intimidate us into silence. You have laughed at us, you have chastised us, you have ignored us, and now you get to listen. I hear you are scared of what this means for us legally, what could happen to us if you say no here. We, the citizens of this village, want you to take this on, and we went so far as ensuring you won't have to fight it alone. We, the Homewood Five, we're standing with you. We were allowed to intervene and join the lawsuit. This means the settlement is toast. We have spines strong enough to fight this. You were elected into your seats at some point. Please do what you were elected to do. Vote no. Vote against disconnection tonight. Thank you for the time.
Thank you.
3 minutes, one more.
Yes, sir.
Yes, good evening. As Mr. Cummings knows, and those who attended the zoning meetings, I'm a retired engineer, so I tend to pay attention to detail. Maybe sometimes more detail than people would like to know. But I've been studying all the petitions in this case. I went through them in detail. I also studied a lot of the paperwork involved, and I also got a lot of nice assistance from the staff of the Village of Homewood in my research. So I wanted to commend them for that. The first question I'd like to ask is in Mr. Cummings' opening statements, he said Homewood has jurisdiction over a majority of the golf course. It's always been a question in my mind, what is that majority? And I asked that because the first petition entered in court had a Homewood bicycle trail attached to it and said, we want that golf course at the north end of the Homewood bicycle trail. That was pretty ridiculous, okay? So they went back and they tried again. By that, I mean the petitioners. And they got a hold of the plat of annexation for Homewood, this big thing. But there's only one problem. This isn't what they own. And Mr. Cummings knows that. This is not what they own. So this was not any good. And then they went back and said, well, you know, let's take our plat of survey and let's just say everything on this, it isn't in Hazel Crest. Well, our own council, as they read it, said that's not acceptable. So my question tonight is, what's being disconnected? And I hope we have that answer, because everything I've read said we don't. So I've seen legal descriptions of blueprints and all kinds of dancing around, but I don't really know if we know what we're disconnecting. And that troubles me. That's my first point. My second point and I want to refer to the notes, and indulge me for a minute, because your earlier comment on the intergovernmental agreement said the golf course sold to the developer. Not true. The golf course defaulted, you can stop me, Mr. Cummings, if I have this incorrect. The golf course defaulted to the hands of a group called CCC Investors. They filed the lawsuit, right? At that time, there was also an area called the West area that they did not own. They did not show on their plat. That was July of 2019. And the village made a case with that West area. And then in February of 2020, a drawing appeared and said, oh, wait a minute, the West area is now part of Calumet Country Club. Don't ask me how that happened. And I know, Mr. Cummings, we tried to make an issue out of that West area. Then all of a sudden, on the most recent plat of survey, the West area reappeared. And I don't know how that happened. And I think the point that you were trying to make from everything I read, we had the small eastern area isolated. We had that western area isolated. You mentioned the eastern area tonight. The western area all of a sudden appears as part of the golf course property. I personally think there are too many unanswered questions to proceed with this right now. That is my opinion. I appreciate everything the village is trying to do, but I think that we're not in a position right now to go ahead and approve an annexation and a disconnection. I'm sorry. Thank you.
Sorry, that's 30 minutes.
Okay, that concludes the audience participation. Mr. Cummings, are there? I'm sorry, we have 30 minutes for debate. That's it. It's written into the rules. Chris, do you have any comments to make?
Now, ladies and gentlemen, the 30-minute rule is a village ordinance. It was adopted in 2017 as part of the Open Meetings Act. And so that's why the 30-minute room, that's where the 3 minutes came from, and that's where the 30 minutes came from for public comment.
Not open for debate. Mr. Craig. Sir, yeah, it's not up to you, sir. Please sit down. Please sit down. You do not have the floor. Sit down, Mr. Cummings.
You're good. Nothing further.
Nothing further. All right. It should be remembered that has been stated before, we are at, may I, if you interrupt, you'll be leaving. Okay, ma'am, this is your only warning. You'll be leaving the building if you interrupt. It should be remembered, has been stated before, that we are at this point because as recently as last November, about 4 months ago, Hazel Crest refused to stand with us, to not accept Calumet Country Club if disconnected from Homewood. Please remember, if that had occurred, we would not even be discussing this matter this evening. A settlement agreement would not have been needed, nor would it have been entered into. Recently, Hazel Crest Mayor Alsbury has indicated a willingness to work together regarding the future of Calumet Country Club. It is with this spirit of cooperation that we have sent the earlier approved resolution to Mayor Alsbury and his board. We are hopeful that we can work together in the interest of both Homewood and Hazel Crest. Board comments. Trustee Dawkins.
We are here because of our consistent opposition to developing a distribution center at the site of Calumet Country Club. It was this opposition to this development which made the developer sue the village for disconnection in the first place. The village vigorously defended this lawsuit for nearly 2 years, filing numerous motions and making numerous court appearances. However, upon reviewing both the statutes and case law, our experienced and learned legal counsel determined there was no way for the village to prevail at trial. The property would invariably be disconnected. At that time, Hazel Crest was engaging in their own talks with the developer and maintained a neutral position regarding disconnection and allowing the development to move forward if the property was annexed into Hazel Crest after disconnection from Homewood. The village board did what it thought was best, which was to settle the lawsuit to maintain some control over the development and protect the residents of Governor's Park and the greater Homewood community. It was only after the village signed a settlement agreement with the developer that Hazel Crest spoke out against the proposed use. Make no bones about it, without the settlement agreement, that would not have happened. The settlement agreement guaranteed the developer a process to which this village and this village board adhered. After the unanimous vote of the Planning and Zoning Board against the developer, against this development, the village board denied the developer's petition to rezone the property. The settlement agreement allowed the developer the right to disconnect from Homewood if the zoning was denied. The developer served the village with their disconnection notice on March 30th. The settlement agreement requires the village board to act on the disconnect at the next regular board meeting, which occurs at least 14 calendar days after receiving the disconnection notice from the developer. And here we are. On March 11, 2021, 5 residents filed a petition to intervene in the disconnection lawsuit pending against the village. Their position was that the case should not be settled, but should instead go to trial. On April 6th, the Honorable Judge Kirby allowed the intervention by these residents, and the residents were given until April 22nd to file their answer to the disconnection complaint. The developers clearly stated their intention to hold the village to the terms of the settlement agreement, which required the village to pass an ordinance allowing for disconnection. However, after the judge allowed the residents into the case, their attorney sent the village a letter claiming that the judge's action in allowing the residents to intervene nullified the settlement agreement. The residents' attorney also threatened to seek sanctions against the village for proceeding with the settlement agreement. The village filed an emergency motion for clarification before Judge Kirby, seeking to resolve this conflict. On April 6, Judge Kirby entered an order stating the following. I'm going to share my screen to actually show you that order. So you can see it for yourself. This is the actual order. It states, the court's order granting the petition to intervene, first of all, did not void the settlement agreement by and between the petitioner and the village of Homewood. Number 2, it did not make the settlement agreement voidable. And number 3, it did not modify any of the village of Homewood's obligations under the settlement agreement. It's clearly in black and white in the order that is in front of you in paragraph 2, all of these things. It did not make the settlement agreement voidable. It did not modify any of the village of Homewood's obligations under the settlement agreement. It did not void the settlement agreement by and between the petitioner and the village of Homewood. If you don't believe me, look at the order. It's right there in black and white, signed by Judge Kirby and entered in to court on April 6th of 2021.
Sir, if you interrupt, I will ask you to leave. Mr. Keating, this is your only warning. You'll be leaving if you interrupt. Go ahead, Trustee Dawkins.
The order doesn't lie. The order's there in black and white. It was entered into court, and that is what the judge ordered. That is not conjecture. That is not opinion. That is not someone spouting off. That is the order that was entered into the court. There's been a lot of misinformation that has been spread throughout this time period. Number 1, the first bit of misinformation that has been spread, that the village is already in breach of the settlement agreement by not approving the zoning. Not true. A settlement agreement cannot guarantee zoning. It can only guarantee a full and fair process for the developer. We gave this developer a full and fair process, 20 hours of testimony and cross-examination. The village is not in breach. Another bit of misinformation. There's no such thing as a mutual mistake of belief. It's something that's completely made up. It's complete misinformation and misguidance. The lawsuit involves disconnection and disconnection only. And as a matter of fact, the judge made that clear during the hearing where she allowed for the intervention, that this is a case about disconnection. It's not about zoning. It's not about considering what's going to happen to this property if the disconnection occurs, whether it's a butterfly farm or it's some sort of landfill. That isn't the concern of the court. The factors used to determine disconnection do not consider the future use of the property. Though this may seem counterintuitive and unjust, that is the law. What Homewood thought Hazel Crest would do in terms of development of the property is not a factor in this lawsuit at all. It is not a defense. While it may be compelling to the court of public opinion, it would not hold up in a real court of law. Number 3, another bit of misinformation. The Illinois law does not provide for a separate penalty for breach of contract. While this may technically be true, it's very misleading. Illinois law does provide for a party to seek damages for breach of contract. Otherwise, there would be no purpose of drafting contracts in the first place. In our case, if we breach the contract by not approving the disconnection, we would be looking at payment of substantial damages and attorney's fees. And another bit of misinformation, that the judge has to sign up on the settlement agreement. Not true. The settlement agreement is still binding on the village. The judge was not a party to the settlement agreement and does not have to sign off on it for it to be legally binding. The settlement agreement was not affected by the judge's allowance of the intervention. The village is still obligated to adhere to the settlement agreement or face another lawsuit by the developer to abide by the settlement terms. In that lawsuit, the village would be subject to claims by the developer for damages and reimbursement of legal fees. The interveners had the option to file for a temporary restraining order to prevent the village from voting on this dissolution ordinance tonight. However, they chose not to do so, probably because they would not be able to prove that there was a substantial likelihood that they would prevail at trial. It is for all of these reasons that I will be voting to approve the disconnection ordinance. The village has fought this battle for almost 2 years, and it is now time for us to work with Hazel Crest to ensure the most favorable outcome for Homewood, Hazel Crest, and the greater Southland area.
Thank you, trustee Dawkins. Trustee Purcell.
Well, trustee Dawkins laid it out pretty clear, exactly where we're at and exactly what we've been up against. The only thing that I want to add is, again, that it's been the events over the last 2 years that have brought us here. This is not a mistake of bad decisions. It is the consequences of where we are. It's not a choice. It's an obligation.
Mr. Crabtree, one more outburst and you're out. Please, we gave you the courtesy. Please give us the courtesy as well. That's all I'm going to tell you. I'm sorry. Sir? Sir, please, I'm going to ask you to leave the room. You've been told not to make an outburst. I'm asking you to leave. You can listen to it outside. You're not going to interrupt the proceedings. Go right ahead. Sir, are you going to leave? Think fast. Sir, I'm asking you to leave, please. You interrupted. We never interrupted you.
She did.
No, sir, please.
She did. You think that's courtesy?
Yes,
To
sir.
arrest someone, a lawyer?
Thank you, sir.
No, you said that, all right.
Thank you, sir. We extended everyone the courtesy when they spoke. We expect the same thing in return. Trustee Purcell, excuse us. Go right ahead.
This is our legal obligation to follow through with an agreement that we've made. Never in the course of this entire project has our what we wanted to do not been in the village's best interest. From day one through now until this is finalized, that is all that we are expecting is the best that can happen for not only us, but our surrounding communities as well. That's all I have.
Trustee Roman?
So For me, it wasn't really about the settlement agreement. And we have our obligation under the settlement agreement. And I know that there have been arguments about the validity of it and do we breach it? Do we not breach it? For me, it was all about the final outcome here on the disconnect case, about the big picture. I was a paralegal for 13 years downtown at two of Chicago's top law firms. I reached out to some of my former colleagues for advice on this. I did my own research. I wanted to hear their opinions outside of this. No one I spoke to sees any different outcome than what has already been advised to us by our legal counsel. So, and I'll reiterate what Trustee Dawkins had mentioned about the TRO. The attorney for the interveners did have an opportunity to file a temporary restraining order to stop this vote tonight, but in order to do that, he would have to lay out a strong defense to the disconnect case. I think we can all assume that by him not filing the TRO, he does not have a strong defense to the disconnect case. So everywhere you turn, we do not have, I don't blame him for that. We don't have a strong defense for it either. So everywhere you turn, we don't have a strong defense to the disconnect case. So the land will eventually disconnect, either way you look at it, either by our vote tonight or by a judge's order. So the question to me is, how much more do we want to spend on fighting a losing battle? We breached the settlement agreement. We pay additional attorney's fees of our own, potential damages to Walt Brown, possibly his attorney's fees. It goes on and on and on to fight a battle that we knew we were going to lose just to get the same outcome. So for me, it boils down to a financially responsible decision. And for that reason, I also will be voting to allow the disconnect.
Trustee Heiferman?
Admittedly, all the social media activity has led me to question my confidence in my own understanding of tonight's ordinance, and to approve the disconnection. So with an open mind, I sought advice from village management, village legal counsel, and I also sought the opinions of my knowledgeable, trusted personal advisors who are not connected with the village. Universally, we've disagreed with the words and some of the fear mongering of individuals and some others that have.
All right, sir, you're leaving. You're leaving.
It's the people of governors.
Sir, you're leaving.
It's the people of governors.
I'm asking you to leave. Excuse me, Trustee Heiferman. You have to leave now. We aren't taking any outbursts.
I understand. I'm in peace.
Please.
I'm in peace. I'm in peace. I'm in peace. I'm sorry. You don't have to. Don't worry. Thank you.
I'm sorry, Trustee Heiferman, please continue.
I'm sorry that this has evoked such emotion and frankly, misunderstanding of our position. I've reviewed the facts again. I think I have a solid grasp of the issues. It's not a matter of fear or courage or bullying, or what's in my heart. It's really a matter of obligations to the community and obligations that we've taken on. I appreciate all the consideration of those who've been, let's say, patient, whether it's residents that I've spoken to, and advisors. And, I've considered all of the communications, and my vote is what I sincerely believe to be in the best interest of Homewood and its residents. And I'll support the ordinance to approve disconnection of Calumet Country Club.
Thank you. With all that being said, Is there a motion to approve ordinance M 2164, the voluntary disconnection of that property?
So moved, so.
I'm sorry? Is there a motion?
So moved, Purcell.
Been moved by trustee Purcell. Is there a second?
Second, Roman.
Second by Roman. Roll call, please.
Trustee Dawkins,
Aye.
trustee Purcell,
Aye.
trustee Roman,
Aye.
trustee Heiferman.
Aye.
Motion is approved. If you'd like to take a short recess, go right ahead. Thank you for coming.
Everybody, power. You don't represent the village, represent.
All right. Would anyone else care to leave before we discuss budget? Go right ahead. Item 11, new business. Mr. Bubinek, budget presentation and discussion.
Thank you, Rich. Tonight, we discuss the draft 21-22 budget. Items from tonight's discussion, any changes, etc., will be brought forward to the board in 2 weeks with the final budget ordinance. I think we have to start this year's budget by looking at where we were 12 months ago. And you all remember that 12 months ago, we were dealing with a shutdown of the US economy right here in Homewood due to the COVID-19 situation. That happened right at the end of our budget. So we have to make some last second cuts to the budget. And on a revenue side, we adjusted our sales tax down 14%, places for eating tax down 15%, income tax down 17%. So some rather large cuts, but based on what we were seeing could happen with an economic shutdown. Now, with such cuts in revenue, we went to the expense side of the budget a year ago, and there's 20 items listed on page 2. I'm not going to go through all of them, but those were the type of items that we thought we could postpone for a year. And then if things picked up and got better, we could bring them back into the budget. One example is we suspended a year ago the annual pavement marking program at 120,000. So we took a year off, figured that, that year off wasn't going to, be terrible, and we could try to pick this up in a year. So that's kind of how we approached it. With revenues going down a year ago, we looked for those type of expenses. So what we ended up with then was a little bit of a budget deficit. In our case, $22 million budget. We used $286,604 of fund balance on hand, or about 1%. So that's where we were a year ago. So now in page 3 and through page 7, then we'll talk about this year's budget. Tonight, we present the 2021-22 draft budget. Again, any changes from tonight we'll bring to the final budget in 2 weeks. We always start out with our general fund. It gets the most scrutiny, but it is what defines local government. And that's our day-to-day operations, dominated by the services of police, fire, and public works. So our COVID situation on, say, like sales tax probably wasn't as bad as we expected. But a lot of our smaller line items, fines and fees, those type of things, those either dried up or didn't happen at all. So kind of good news, bad news. Maybe sales tax wasn't as bad as we thought, but a lot of the smaller items did go down. So I do list the top 5 revenues for the general fund on page 3. Sales tax was increased by 19%. Again, it was, remember, last year was decreased by 14%, place for eating tax 17%, income tax 26%. So that is going to be something, again, I mentioned here, that some of our smaller line items, fines and fees, are down like 300,000. So in general, revenue picture, we're trying to get back more towards normal. New to the revenue picture, though, last year, and now we have a full year going into this draft budget, was a gasoline tax that the state allowed, and a recreational cannabis tax that the state also allowed. So each are budgeted for this coming year at $360,000 each. It's based on, the partial year that we have data on. On the expense side, we're driven by collective bargaining agreements, and all 4 union contracts are under negotiation at the same time here going into this budget of 21-22. We were able to add back some of the expense reductions from the COVID-19 budget of a year ago. Again, I won't go through the whole list, but for example, we're funding 100,000 into pavement markings to offset the 120,000 that was cut out of the budget a year ago. So that's, like as I said earlier, we cut some stuff out that we hope we could get back in this year and that we wouldn't get too far behind if we skipped a year on. And I think that's a good example, pavement markings. There's others here, but again, I won't go through each one of them. But we did come to the end of our budget with still a slight deficit, $172,604. On page 4, we offer a couple of options here that staff came up. Our option A is maybe a little bit heavier on the revenue side. That would be some of the fire department collections that they do for ambulance runs, along with one expense reduction of a Medicare B supplement for retirees over 65 years of age, which we really can't afford anymore. But for those of you that want more than an option, or maybe want to mix the two options up, A and B, our B option then is expense reductions. A planner position is not funded. We look at a lower cost of living number and eliminate a Think Homewood campaign, reduce our non-TIF business incentive programs. Again, those option B to balance the budget are all expense reduction. So again, A, B, combination of A and B, we'll be debating that here between now and 2 weeks from now. That does eliminate our deficit. And I think a balanced budget is crucial to the long-term financial interests of our local Village of Homewood operation. It's okay to be unbalanced for a year, like a year ago with the COVID unknown, but we want to get back to that balanced budget. So we do offer some items here that would get us back. Onto the water and sewer fund, we're in the middle, or that, I guess that would be, not, shouldn't say the middle, at the beginning of a big switch from Hammond Water through Chicago Heights. So that is underway right now. We've actually paid a number of bills on that project as we move here towards May 1st. So big project for water and sewer fund. We've certainly talked about that quite a bit at previous board meetings. Capital Improvement Funds, CIP. We talk about on page 5 where we get the money to do these capital projects, which are those long-term, long-lasting equipment and infrastructure projects. So probably one of our more popular ways of finding funds is the state-allowed 0.5% equalized assessed value bonds. We did issue that this past year at a record low rate, which we'll never beat again, 0.85%. So we were able to borrow that money to get some capital projects on the books and getting ready to start working on those capital projects. Not interest-free, but almost interest-free. So that was quite a great thing that we were able to do this past year. Move on to the pension funds. It's more of a discussion in December when we set the tax levy. How much money can we allocate towards pension funds? Because we have to balance that with what we allocate towards day-to-day funds. But in general, the pension funds show a healthy balance in our yearly audit. So that's good news. The TIF districts, tax increment financing, best economic development tool allowed by the state to local government, maybe the most misunderstood, but it is the best. We use that increment to fund infrastructure and economic development incentives. So that's where the money's spent in the TIF district. Special revenue funds dominated by the motor fuel tax fund. We did get from the Rebuild Illinois program $600,000 this past year and a projected $600,000 for next year. That will be used for road resurfacing. So Rebuild Illinois program, we'll be using it for road resurfacing. Debt service funds, we don't have much debt. There's not a whole lot in there, tell you the truth. Last bond was at 0.85%. So we do have our debt service funds. Lastly, we have fund balance. What's the correct amount of fund balance? Some communities have a whole bunch and some have none, but in general, about 3 months of fund balance on hand is the norm throughout local governments. We have about 2.7 months on hand right now, a little bit below our targeted level. We do have some things on the horizon. Couple of demolition buildings, Triumph Building and the Bogart Building. If we should do those and move forward on that demolition, they'll probably have to come from fund balance. So 2.7, maybe it's 2.5. Again, the average in our policy is 3 months. Fund balance use is appropriate, given unforeseen situations like we had a year ago. But the use of fund balance cannot go unrestrained, as there is a limit to fund balance. Once fund balance is gone, it is gone. That's why the option A and B earlier was to get a balanced budget. Stimulus funds from the federal government got a lot of media attention about a month ago. As far as the Village of Homewood, it's projected to get $2.3 million. We did not budget any of this money because it's not in-house. We will wait. Should it arrive, we'll bring back some of the items that we cut out of this budget for discussion. But as of right now, that would probably be $2 million towards capital projects. And we'd use about $300,000 to replace some of our smaller revenue streams that were reduced or lost by COVID-19. So both are allowed from the federal government with the stimulus funds. But again, until it shows up, we're not budgeting anything. We'll come back with budget amendments when it does show up. Conclusion, you've heard it 100 times, so here's 101. The budget process is our most important planning tool. It allocates revenues that we have available to the expenses that we are expected to provide, dominated by public safety and public works. There's always a desire for more of these services than we have revenues to fund. But through the yearly budget process, we balance our service level with the revenues we have at hand to pay for those services.
Thank you, Mr. Bubenik, and I'd be remiss if I didn't acknowledge that lady up in the upper left-hand corner, Amy Zakowski, our Assistant Finance Director, who certainly has her footprint, handprints all over that budget. Thank you for everything you've done as well. Any comments or questions from the board? It's in spite of the times, it's an optimistic picture. There's a lot of towns that are suffering so badly, and we're holding our own. Trustee Dawkins?
I don't really have any comments except to thank you, Amy, and everyone else, all of the heads, department heads, for all of the work that you consistently have done and that you continue to do with respect to the budget. It's always one of those it is what it is type situations, but I appreciate all the work that goes into it and keeping us financially stable and actually really good financial, a really good financial state consistently. Thank you.
Trustee Purcell?
I agree 100%. Thank you for everything, and your explanations on everything are make it so easy for us to understand. And you've done such a wonderful job for us. Thank you so much.
Trustee Roman?
I agree with the comments of the previous trustees. Thank you guys very much, Dennis and Amy, for all of your hard work and all of the department heads. It's very much appreciated.
And Trustee Heiferman?
In the memo, there's a couple of options listed that will help balance the budget. But I just have a brief question about the ambulance fees. How does that affect residents? Are there ambulance fees for residents?
Chief Grabowski?
Yeah, we have resident and non-resident fees. The resident fees are a little bit lower. Again, the majority of our revenues that come in through that are coming in through private insurance and Medicare. Medicaid is of course, a lower amount that we receive revenue on as well. We're in the middle of working on a new program in Illinois, somewhat new. It's called Ground Emergency Medical Transportation, which will allow us additional revenue on the Medicaid side and on the Medicare side where people may not have supplements. That comes directly to the state from the federal government. It is a long and lengthy program that I will probably explain down the road in the next couple of months. But that's where we're looking to pick up that additional revenue from.
I know this is a side note, but I hope we have some generosity for residents who have difficulty and as well as not having insurance. But if this is not a tremendous effect on residents directly, I'd like to just suggest we go with both Plan A and B, thus creating a surplus of over 100,000, and use that surplus partially to help with some of the emergency repairs needed for the new science center facility, and to help the fund balance. So
Mr. Marino is taking notes as you're speaking, and he'll certainly bring that forward to us. Is there anything else, trustee Heiferman?
I have nothing else. I know it's a tremendous effort to create the budget and maintain it, and kudos to all who do the hard work.
My question to Mr. Bubanek and Mr. Marino previously was much like yours. If we do increase this ambulance fee for lifts and so forth, is it covered by Medicare and insurance? And I've been assured in the majority of instances it is.
It is, yes. And we do, if we do have a situation where resident or non-resident, the company that we contract with is very good at working with them to work out a program for paying. Makes it very reasonable for them.
Okay, thank you, Mr. Bubanek. Look forward to the actual budget coming before us. General board discussion, trustee Dawkins,
Nothing.
trustee Purcell,
Nothing else.
trustee Roman,
I have nothing.
trustee Heiferman.
You've said it all.
With that, may I have a motion to enter into executive session to discuss pending litigation? May I have a motion, please?
So move Purcell.
Second, Roman?
Been moved by trustee Purcell, second by trustee Roman. Roll call, please.
Trustee Dawkins,
Aye.
trustee Purcell,
Aye.
trustee Roman,
Aye.
trustee Heiferman.
Aye.
Take a short recess and we'll join one another in closed session. Thank you all.